Imagine that your face and words are worth 1 billion naira and someone else is using them without your consent or adequate compensation. This is a story of Sabi, Investor Sabinus. This story starts in 2015 when Sabi was a student at the University of Port Harcourt studying linguistics and communication. While on campus, Sabi performed comedy at student events and began creating skits, not just because he believed he had a career or a future in the entertainment industry, but because he genuinely enjoyed making people laugh. Sabi began creating and posting skits online even when only a few persons ever watched. His skits had him as an unfortunate and stupid person who constantly fell into trouble. The character fitted perfectly with his blue shirt, black trousers, black shoes, and black or red tie. His fans believed that he never needed to utter words to provoke uncontrollable laughter. The storyline of his skits and his facial expressions were enough. Still, Sabi's skits never gained traction until in 2019, when popular celebrities and entertainment blogs began reposting them. His follower count and watch time exploded. Brands began noticing him, and Sabi became one of Nigeria's biggest comedy creators. By 2022, Sabi had bagged several multi-million naira endorsement deals and won many entertainment awards, including the Best Online Social Content Creator Award at the AMVCA. In one of his Investor Vibes kits, published sometime around October 2021, the phrase "something Hooge" was born.
I'll give you my pin, make it whole. I'd expect something Hooge next week.
Because of the popularity of this phrase, it became so valuable to the Sabi brand that he applied to trademark it at the Nigeria's Trademark Registry sometime in November 2021, and it was accepted in December that same year. In May 2022, Friesland Campina, the company that owns Pigmail, published an advertisement on the Pigmail brand with a bold display caption, "Something Hooge is coming," in one of its Pigmail's campaigns. Around the same period, Gala, a product of UAC Foods, shared a promotional content where they used the cartoon likeness of Sabi. Seeing this, Sabi alleged the unauthorized use of his intellectual property and image rights and sought compensation of 1.1 billion naira through his lawyers' demand letters to both Friesland Campina and UAC Foods, the owners of Pigmail and Gala. The story quickly became a national news, and while it dragged online, two things were discovered. Firstly, the trademark certificate for which something Hooge was filed was yet to be issued. Secondly, something Hooge was filed not just under the classes that covered insurance, financial services, and real estate, but also under the class that covered entertainment and advertising. Seeing that the matter could not be settled out of court, in August 2022, Sabi's legal team filed two suits at the Federal High Court sitting in Abuja for trademark infringement and the other with an element of passing off. After several years of no court judgment deciding whether an infringement or an unauthorized use had indeed occurred, the matters were resolved through amicable settlement in early 2026. All parties won, I guess. But what if the court gave judgment? Who would have emerged victorious? Well, for Sabi's trademark dispute against Friesland Campina over the Pigmail advertisement, trademark is registered in classes. Assuming without more that Sabi registered something Hooge under the insurance, financial services, and real estate class alone, and not under the advertisement class, it will become difficult for Sabi to establish any trademark infringement claim against them, because the business of Friesland Campina and indeed their act of advertisement did not bother on insurance, financial services, or real estate services. Would it make any difference that Sabi was yet to receive a trademark certificate? Comment Sabi's trademark certificate if you want me to answer this question. And on the cartoon or illustrator likeness of Sabi used by UAC Food on its Gala advertisement, making a caricature of a person and using it for non-commercial purposes may amount to parody, and parody is an exception to copyright infringement under Nigerian law. to the principle of fair dealing. It is called fair use in the United States. However, if the cartoon or illustration likeness was used for commercial purposes and it bears the exact posture of Sabi in real life, it could amount to passing off, as it could mislead the public and indeed Sabi's fans into believing that the product was authorized, endorsed, and affiliated with Sabi. Check the Rihanna and the Topshop story and the what if to see what I said on what constitutes passing off. For creatives, it is your choice to wait until your work, name, logo, catchphrase, or slogan becomes famous before protecting it. It is your choice. As an intellectual property law expert, I know that protecting it early can be a game changer. For businesses, you should know that prior IP ownership research and IP licenses exist for a reason. Because the rule is simple. You either own it, or you license it, or you lose it. I am Mr. Ujong, a startup, IP, and consumer protection lawyer.